Marr against Wong and others.
Mr. Crowe.
May it please the board, the list of representation is in front of you, so I don't think I need, without discourtesy, to introduce anyone. Can I assume that the board is entirely electronic, in which case I can just give electronic page numbers rather than physical bundle numbers?
I think that's right.
I'm grateful. And I think you've also been provided with our timetable, so I don't need to let you know who's going when and for how long.
No.
In terms of roadmap, I just...
You may want to take a short pause at the end of your submissions, which would be on the current plan at about 2:45.
There may be another possible natural break in the morning if that is convenient, simply because there's one issue on which my learned friend Mr. Bedinghouse is going to address the board, which is the point in Malaysian law. But can we just see how we go?
Very well.
What we wished to do was simply to make one or two preliminary observations and then to address you under three main substantive headings.
Just before you do, Mr. Crowe, you may have this in mind anyway, it would, I think, probably be helpful to us to be updated on the current state of play in the other relevant pieces of litigation. And by that I mean the litigation about the other blocks of shares in Realty, but importantly, the litigation, if it's still ongoing, about whether Realty should be wound up.
That was meant to have been heard in the appeal court, I think, on the starting on the 30th of November, but it was adjourned. So the current position is that the appeals in relation to the winding up order on WTK Realty and the appeals in relation to the 4 million block of shares, OS 39, and the appeal in relation to the 1.275 million block of shares, the 14.4 writ, those appeals are all outstanding, and I'm not certain...
And is that the first appeals? Because the judgment winding up Realty was slightly earlier, wasn't it, certainly than the Court of Appeals judgment in this case?
Yes, it was. The winding up order in relation to WTK Realty was made, I think, on the 6th of November 2017, which I think was the last day of the oral hearing of the trial in this matter.
So the appeal's outstanding, what, slightly over 4 years on?
That is...
And that's a first appeal?
Yeah.
And what is happening to Realty in the meantime? Is it simply that the order has been stayed, or is there some interim arrangement?
I know the order has been stayed. I don't believe there's any interim... there's no interim measures in place. So the winding up order is simply stayed.
So it's effectively stood under the control of its management?
Yeah.
Right. Thank you.
And obviously, we have no insight into how long that state of affairs will last. The position we would submit is that the decision of this board simply has to be taken, for good or ill, in the knowledge that the winding up order has been made, and with uncertainty as to when the appeal will be heard, and if so, what its outcome will be. The three substantial headings that we wanted to address you under are these. The first point is that our submission is that in reaching the conclusion that equitable considerations are not in play in relation to STIC, the courts below failed to appreciate the legal consequences of indisputable facts. We would wish to emphasize that at the very outset, because you will have seen from my learned friend's case that he wishes you to believe that this appeal is nothing but an appeal against concurrent findings of fact. And the first and the main part of our submission is a submission that the courts below fail to recognize the legal consequences of indisputable facts. So that will be our first main heading. The second main heading will be that even if equitable considerations are not in play, nevertheless, there has been unlawful conduct, there has been a loss of confidence, justifiable loss of confidence in management, and there's been a loss of substratum, all of which, again, we would submit is a case founded on indisputable facts and is sufficient to justify the grant of relief under Section 184I. And the third and last heading for our submissions is that in relation to the purpose for which the conversion of the convertible preference shares, the CPS, the purpose for which that was effected is an issue, unusually, in which we do submit that this board is entitled to revisit the facts. I'll deal with that one last, and I'll explain the basis upon which we do so. Now, there is plainly an enormous amount of material that has been put in front of you, both in relation to our written cases and the referential inclusion of various submissions that were made in the courts below. We are not going to have time orally to address you on everything. What we wish to do is to address you on the points that we think will assist you most by not addressing points that are covered in our written case orally. We do not in any sense intend to retract them. It is simply that we recognise the constraints of time within which we have to operate.
So I think I understand that to mean that you don't abandon any of your submissions about where we should depart from the courts below on the facts, but the only one you're going to concentrate on orally is whether the courts below got the purpose of the conversion right.
Exactly.
Yes, thank you. I should say that subject to submissions, our reading of the settled practice not to reopen concurrent findings of fact suggests that it doesn't just mean we approach the resolution of the matter with a disinclination. It may mean that we don't go there at all, but under the constraints of time with which we're labouring, our current view is that we should simply go there, as it were, di bene esse, without deciding until the end of the day whether we shouldn't actually go there at all, because we are mindful that that is at least one interpretation of what this self-denying ordinance adds up to.
Well, I entirely accept that, but as Your Lordship very fairly said, both for reasons of time, but also for reasons of practicality, one does need to go there, de bene esse, in order to decide whether this is one of those exceptional cases that falls outside the usual box.
Our disinclination to take it in 2 bites does not imply any conclusion that we ought to be going there.
No, I entirely accept that. I have my work cut out. The preliminary observations we would make then, before going to those 3 headings, the preliminary observations we would make are simply these. First, that in a shareholder dispute such as this, we would submit that you know something has gone wrong when the trial judge dismisses the claim but grants relief, which is what happened here. And you know something has gone fundamentally wrong when the respondents do not appeal against the order which has been made, despite the claim having been dismissed.
Well, they might be perfectly happy with it.
And you know with respect that something remains fundamentally wrong when the Court of Appeal does not overturn a ruling from the court below, dismissing the claim and granting the relief. Now, Malone and Friends says you don't have to decide whether the judge at trial had jurisdiction to make an order under Section 184, having found that there was no oppression, undue discrimination, or unfair discrimination or unfair prejudice. And in a sense, that is right, because neither side is asking to set aside the buyout order. But we do submit either that the judge was right in saying that he had that jurisdiction. If he had the jurisdiction to make a buyout order, he must also, by definition, have had jurisdiction to make any other order under section 184I, including a winding up order, which is something he did not consider doing. If the judge was wrong as a matter of jurisdiction and he could not make an order for a buyout absent any findings of unfair discrimination, prejudice or oppression, then that, in our submission, is symptomatic of a muddled and fundamentally misguided judgment with respect. If we needed to address the issue at all, we would submit to the board that the simple and plain answer is that a court does not have jurisdiction under section 184I to make any order unless it is satisfied that there has been oppression, undue.
Well, what if the parties consent in the sense that, not that they both simply seek that order, because otherwise there wouldn't have been needed to be a trial, but consent to him doing that if he doesn't afford you the primary relief you're seeking?
Sorry.
Does consent confer jurisdiction in this context?
No. With the greatest respect, the court's jurisdiction is entirely statutory. The parties cannot, by consent, enlarge the powers of the court.
Well, what might have happened is what one often finds in a trial court judgment, which is the judge says, I find that there was no unfair prejudice, but if it turns out that I was wrong, if the case goes further, then the relief that I would have granted would have been the buyout rather than the winding up. But somehow it ended up in the order when it shouldn't have been in the order because it was only a conditional.
Well, with respect, it plainly wasn't a conditional ruling because paragraph 178 of his judgment says the fair order to make is a buyout. That's what he says in his judgment. It didn't get into the order by mistake with respect. And that is, I mean, it's the beginning and, in a sense, the end of a large part of our submission, is that the judge could only have reached that conclusion that fairness requires a buyout because of the breakdown in the relationship, which is what he says in 178. He could only have reached that conclusion if he accepted that STIC is a company whose continued existence depends upon mutual cooperation and trust between the parties, because it was on the basis of the breakdown of mutual cooperation and trust that he made the buyout order. And in our submission, what he simply failed to do in the rest of his judgment, and what the Court of Appeal failed to do, was to recognise the logical consequence of that finding. The logical consequence is that the Court has found that it is unfair to keep these parties locked together because there has been a breakdown. It is unfair because the company is founded on a relationship of mutual trust and confidence. Therefore, the claim succeeds. The only debate we should be having in this board, with respect, is what is the appropriate relief, given that that is the conclusion. And in our submission, as we will explain, the appropriate relief is winding up, not a buyout order. The other preliminary observation we just wanted to make is that it is, with respect to the trial judge, clear that he did make a number of mistakes which the Court of Appeal itself recognised and corrected. He was wrong in simply preferring one expert on Malaysian law against the other without giving any reasons at all. He was wrong in applying UK procedural rules in reaching a decision whether or not to allow our amendment application. And he was also wrong in failing to give any reasons for refusing our application to amend the claim form to include the freestanding claims which we were seeking to make under sections 121 and 175 of the BVI Business Companies Act. So it is clear that the Court of Appeal found those errors in the judgment below. The only question in this appeal is whether the first instance judgment contained other errors which the Court of Appeal did not also then recognise and correct. With those very brief preliminary observations just on the context, can I draw your attention, if you haven't looked at it, it may just be convenient very briefly to look at the family tree, which is in the supplemental bundle. I don't know if you have that, I presume, electronically. If you go in that bundle to page 247, or tab 7 if you've got electronic tabs in it, and it turn around side. It's just possibly helpful to see the family tree with the patriarch, the founder, WTK, at the top of the page.
Sorry, could you give me the page reference?
247?
247.
In the supplemental bundle, yeah. And I hope
that I hope is the 345-page bundle.
That is right.
Yes, thank you.
Yes.
Yep. Oh.
So, family tree, we have the patriarch, the founder, WTK at the top. The boxes are colour-coded, so red indicates daughters, blue indicates sons. There is apparently a slight inaccuracy amongst the order in which the daughters appear, for which we apologise. The 3 daughters of WTK are all older than the 3 sons, but nothing turns on that for your purposes. But you'll see, so the first generation is WTK, second generation is KY. It is with no disrespect that we use initials, the family does itself when referring to other members of the family. So the older son is KY, and then KN, who is the late husband of my client, Ms. Ma, and he died in March 2013, as you may know. And then KC, there's the younger brother of the 3 brothers. And then the third generation below that, you'll see KY's son is Patrick. You'll see the name Patrick coming up occasionally in the papers. And occasionally you may see the names of Annie and Happy, his daughters. He has 2 other daughters, but they don't feature. And then my client's son and daughter, Neil and Mimi. And then KY's children, Christopher, Pierre, and Vicky.
You mean KC's children?
Sorry, KC, sorry. There is also, if you want to look in the main bundle at page 3444, there is a corporate diagram, 3444. There's a corporate diagram which shows the holdings in WTK Realty before the conversion. And you'll see that the combined voting power of KN and Neil is just over 54%.
This is on the assumption that the appeals against the orders about shareholding succeed.
This is simply the factual position as it stood in March 2013. That is what the shareholding position was. Whether it should or should not have been is a matter that is being debated in the courts. But factually, that's what the position was and had been since 2004. And if you want to see the shareholdings reflected in WTK Realty's accounts, I don't ask you to go to it, but you'll see them, those shareholdings reflected in WTK Realty's accounts from 2004 onwards at page 2750. I don't ask you to go to it, but you will see the accounts year after year reflecting those shareholdings. So, as I say, factually, that was the position. Yes, there's litigation about whether it should have been, but that's what the position was.
But the litigation is not about whether they should now be set aside, it's about whether they were invalid, isn't it?
Yes.
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 So it would have, in a sense, a retrospective effect if the High Court decision stands?
I don't know that as a matter of Malaysian company law, but what I would say is simply this. It is the very fact that a dispute has arisen in relation to whether or not those shares should have been issued or transferred, which provides the context in which the courts below should have been considering the motives of KY and KC in effecting the conversion. It is, in our submission, extremely obvious that the fact that KY and KC believed, so they say, that KN was not entitled to a majority voting control in WTK Realty, which explains their motive in effecting the conversion, because the conversion was very simply a case of self-help. They didn't have to go through court process setting aside the 4 million and the 1.275 million allotment and transfers if they could simply convert STIC's convertible preference shares into ordinary voting shares in WTK Realty, because KY and KC de facto control STIC. So by converting the non-voting preference shares into voting ordinary shares, they created a 14.4% voting bloc in WTK Realty under their control. So they achieved the practical outcome which the long and slow, as we know, litigation process in Malaysia may or may not achieve for them. And that is an enormously important part of the factual context, which simply doesn't get airtime in the judgments below. The chronology, I imagine you have well in mind. WKN, the late KN, the middle brother, although not the oldest son, became managing director of most of the WTK company, group companies. STIC was incorporated in 1996 with 3 issued shares, each of which was held by a trustee, Gainesville, which held the shares with, under 3 individual declarations of trust, 1 each for KN, KY, and KC. In 2004, it was issued with 55 million convertible preference shares. I won't ask you to turn it up, but if you want to look at the amended articles of WTK Realty, which identify the rights attaching to those shares, it's at page 2670. And the critical points are that the convertible preference shares had no votes, so STIC did not have shareholder power, so to speak, at general meeting level in WTK Realty. But it had a right, the convertible preference shares had a right, obviously, to a preferential dividend. It was not a fixed coupon. It was set up, structured in a way that could have been used to take retained profits out of WTK Realty and indeed take them offshore for the benefit of the family members, in preference over all the ordinary shareholders. So it is critically important to keep in mind that the preferential dividend is not a fixed coupon, and it is preferential. Then, as you know, in 2000...
Am I right in understanding that on liquidation of Realty, the conversion would give, and it would presumably be at a very substantial surplus, a very solvent liquidation, a conversion would give STIC a share in the surplus, whereas the prefs would just give STIC a fixed payment,
yes,
equivalent to the face value of the prefs.
Yeah. Yeah, but actually the entitlement of the prefs in a liquidation is actually not their face value. It is a little bit more, but not,
it's a fixed amount.
Yeah, it's a fixed amount, exactly so. Yeah. It's a fixed amount. And the accounts do show, I mean, there are massive retained earnings in WTK Realty, something north of 500 million Malaysian ringgit. I can't give evidence as to exactly what that converts to in sterling, but no doubt one can look that up fairly readily. 500
million, did you say?
I'm being prompted. It may well be well over $125 million.
Okay.
In 2011, I think I got very briefly, KN fell ill and went to Australia. KY took over as managing director in Cebu in Malaysia. In March 2013, KN dies, and in less than a month, the preference shares are converted into ordinary shares, which, as is common ground, gives KY and KC de facto control over a voting bloc of 14.4%, thereby neutralising what would otherwise factually have been the majority voting.
What's that percentage again?
14.4%. And these proceedings were then brought in order to reverse that outcome. The trial, as you know, took place before Justice Adderley in late 2017, Court of Appeal hearing about 10 months after judgment at first instance. Now, as I say,
the proceedings included setting aside the conversion as a concrete aspect of the relief sought, as I understand.
Yes, that was one of the...
just unfair prejudice relief, which would, on the face of it, be an internal matter for STIC, whereas the conversion, the setting aside the conversion, would be a matter closely, possibly even primarily, affecting realty.
Well, indeed it would. I mean, if the court in BVI had granted relief setting aside STIC's decision to convert, that would not have been of any use unless it was a judgment that could have been enforced in Malaysia against WTK Realty. And so it does...
Realty wasn't joined
no.
in the BVI proceedings.
No. So
a mere setting aside of the decision to convert wouldn't unconvert shares.
No, it wouldn't. It does, in a sense, narrow the practical utility of the available relief that is available to the BVI court. Now, as I say, Malone & Friends' efforts are going to be directed towards persuading you that this is nothing but an appeal against concurrent findings of fact. And our submission is that that is an oversimplification, and that there are a range of different kinds of issue on which we will be addressing you. There are, first of all, pure issues of law. For example, when we get to it, was there a breach of the Business Companies Act, Section 175, a disposition of more than 50% in value of the assets of STIC without shareholder approval. So there are pure questions of law. Second, there is a question of foreign law, of Malaysian law. It's treated as a question of fact, as a matter of sort of technical classification in the BVI proceedings, but it is purely a matter of legal analysis. It was, and in that context, in our submission, this is in fact a first appeal, not a second appeal, because the judge at first instance simply did not give any reasons for his conclusion. And so the Court of Appeal is the first reasoned explanation for why the other side's expert was preferred. So there's questions of foreign law, which, as I say, is technically a question of fact, but it is purely a question of legal analysis. Third category of issues which are in play are issues we submit of legal evaluation of the significance of the primary facts. And under that heading, in our submission, there are essentially two main questions of legal evaluation. The first is, on the indisputable evidence, was STIC a company in respect of which the court should have taken into account equitable considerations when considering exercise of its jurisdiction under Section 184I. That is not a question of primary fact. The facts are the facts, and the court then addresses the question, well, given that that is the factual matrix, does that give rise to equitable considerations? And in our submission, in terms of categorising the issue that's in front of you, that is an issue of legal evaluation of the significance of the primary facts. And the second issue of legal evaluation is, irrespective of whether equitable considerations are in play, has there, again, on the indisputable facts, has there been oppression, unfair discrimination or unfair prejudice as a result of loss of substratum, unlawful conduct, and/or justifiable loss of confidence in management? So that's the third category of issue. The fourth category of issue is questions of primary fact. And as I say, as you know, the issue that we will be addressing you on in relation to that is as to the question of what was the substantial primary or dominant purpose for which KY and KC implemented the conversion. We'll come to that last.
Can you just say briefly what are the other ones, just so that we know when we go back to your written submissions, which of those submissions you accept fall into this fourth category?
Yes. Can I give you a sort of reading list later on that? Just make a note to do that. Yes, absolutely. So we wanted to start then with the first of those substantive points, the legal evaluation based on incontestable evidence as to whether or not equitable...
Can I just, before you go on, in terms of your pure questions of law, I think your first category, where I think you've been telling us the disposition question under section 175,
yes,
falls within that. Are there any others that you would class as pure questions of law that we are directly confronting? As
opposed to questions of legal evaluation, no, I don't believe so.
Right. Thank you very much.
But is the disposition section 175 question BVI law or Malaysian law?
No, that's BVI.
Oh, it's BVI.
Yeah. Yeah. So first and main heading is the legal evaluation of the incontestable facts as to whether or not equitable considerations ought to have been taken into account in deciding whether or not to grant relief under section 184I. Now, before this constitution of a board, of all, we do not need to labour the elementary points of law that the court will, in appropriate circumstances, take into account not just legal rights, strict legal rights, but will also take into account equitable considerations when considering whether any conduct is oppressive, unfairly discriminatory, or unfairly prejudicial. And I don't need to turn up Westbourne Galleries or O'Neill and Phillips, particularly since several of you have recently been giving judgments, apart from anything else, on appeals, at least one appeal from the PVI on this area of the law. So I was going to simply, with respect and in the interests of time, offer some propositions and give some page references without asking you in court to read any of the case law. The first proposition specifically that we would just wish to urge on you is that the question, and this may be stating the blinding obvious, but worth doing just to put the whole thing in context, the question whether equitable considerations come into play in any given case does not depend on whether the facts of this case happen to fall within any predetermined list of categories. The second proposition is that irrespective of whether a company takes the form of an incorporated partnership, a quasi-partnership company, irrespective of whether a company is or isn't a quasi-partnership, if events have occurred which mean that the company is in a condition which no one could have intended or contemplated when the association began, then it may, in that situation, be inequitable for a minority shareholder to be locked into the company. And the court should, in that situation, reach the conclusion that winding up relief is at least one of the available remedies. Whether it is the appropriate remedy, we will look at more specifically.
So you say that if the events occur which mean that the company is in a situation which no one would have contemplated when the venture began, it may be appropriate to wind it up.
Yeah, exactly.
And do you say that is regardless of fault on either side?
Yes. Fault has never been part of the debate in this case. There is quite a lot of case law on that as well, which hasn't been cited because that wasn't part of the issue at trial. But it is, in our submission, entirely clear from the case law that the entitlement of a petitioner, a petitioner is not disentitled to relief unless they are wholly and solely the cause of any breakdown. As I say, I wasn't going to ask you to turn up Westbourne Galleries, O'Neill and Phillips, or any others. Can I just, for your convenience, offer some page references in these bundles so that you can find the passages that we specifically rely on. So in relation to Westbourne Galleries, which is at page 11734.
Sorry, 1734?
11734.
Thank you.
We would specifically invite your attention to the passage at 11748H, which is the exhortation not to think in terms of categories of case, but to apply equitable considerations as equity does. The passage at 11750D, which reminds us that the court's equitable considerations come into play not only in relation to deadlock situations, functional deadlock, and finally the well-known passage at 11753B, where Lord Wilberforce explained that it is impossible and undesirable to try defining exhaustively the circumstances in which equitable considerations will come into play. In relation to O'Neill and Phillips, again, I won't ask you to turn it up, but for your convenience, the bundle reference is 12800. And the passages we would specifically invite your attention to are at 12807 at B, where Lord Hoffman reminds us that the concept of unfair prejudice runs in parallel with the concepts of justice and equity in winding up. And also specifically the passage at 12809H, which explains how if an event occurs which puts an end to the basis on which the parties entered into association with each other, the court's jurisdiction to grant the relief under, in our case, 184I, is triggered. And I also, just for the sake of convenience, also remind my Lord Briggs and my Lady Arden of what they said in Lau and Chu, very much along the same line. So Lau and Chu is at page 12674. And in this context, I would remind my Lord Briggs of what he said at paragraph 31 and Lady Arden at 101 along the same lines. And finally, if it is of any assistance along these lines, there's a recent judgment in the Court of Appeal of Jersey called FTV and EFTS Capital, which is at 12062, and there is some analysis of the case law touching specifically on exactly these points at paragraphs 63 to 68. The third proposition of law is that where a company or group of companies has been established by a patriarch with the intention of creating family wealth and employment, and the intention is that ownership and control of the company or group of companies should pass from the patriarch to his successors and to his successors' successors, and the business is conducted without formal binding contracts defining participation in management or defining allocation of responsibility between family members, or defining entitlement to remuneration, when the business is conducted essentially on the basis of non-documented, non-contractual, informal cooperation and collaboration between family members. And where there is such a fracture between different branches of the family that they personally and the group companies are mired in litigation, the court is entitled to take the view that equitable considerations come into play in those circumstances, and that it would be oppressive, unfairly discriminatory, or unfairly prejudicial to leave a minority shareholder locked in without granting appropriate relief. And as you would have seen from our written case, our main authority on that is Chow Kwok Chuen, Singapore Court of Appeal judgment, which is at page 11208. And we've quoted certain passages from it in our written case.
I'm so sorry, 112.
11208.
Thank you.
And we would particularly urge on you paragraph 31, which is at page 11222. We would also invite your specific attention to the decision in Lin Chu Mi, which is page 12700, specifically paragraphs 74 and 75, at page 12718. Thirdly, to the case of Malos and Malos, which is page 12744, specifically paragraphs 4 to 6, page 12746, and paragraphs 24 and 25 at page 12750. And finally, Fisher and Cadman, page 12017. And we would urge on you specifically paragraph 89, which is page 12046. Final legal proposition we just wanted to touch on is this. My learned friend's case, as you will have seen, has expended a considerable amount of energy urging on you that Lord Hoffman in O'Neill and Phillips said that there is no such thing as a no-fault divorce under the English 994. In other words, it is not sufficient for a shareholder in a company to come to court and simply say, I'm not getting on with my fellow shareholders, I'm entitled to relief. We entirely accept that. If you want to see a subsequent examination or exposition of the no-fault divorce case, you can find it in one of my learned friends' cases, actually Grace and Bajoli, which is at 12232, and specifically at paragraph 77, which is at page 12260. There is, I think, nothing actually between us on this particular point of law. We entirely accept that the court's jurisdiction under section 184I to grant relief is conditional on the claimant establishing that there has been oppression or unfair discrimination or unfair prejudice. Simply coming to court saying, I'm not getting on with my shareholders, of itself is not enough. We do accept there has to be, for short, unfair prejudice. And we accept that unfair prejudice can be found in a number of different situations. It can be found if there has been unlawful conduct, a breach of a legal right, and it can be found if there is, in a circumstance in which equitable considerations come into play, reliance on a legal right, which is, in the circumstances, unfair. That is why we are addressing you on the question of whether equitable considerations do come into consideration in relation to STIC. So, just breaking down under this first and main heading.
And just to anchor that, you're saying that the conversion itself pressed all those buttons?
Yes, absolutely. So, just breaking up the. I
mean, you started off by saying there can be a fracture between members, and they're all mired in litigation.
Yeah.
But at what point then does the right to come to court arise? Because you just replied to my Lord Briggs, it's the conversion that you're worried about. But the conversion, I think, is the effect rather than the cause of the breakdown, isn't it?
Well, I'm not sure as a matter of analysis it is one or the other. There is certainly a starting point is clearly that there are not particularly good relations. And then the conversion is essentially a declaration of war. So it is both a symptom and a further cause of the breakdown. And if my lady's question, in a sense, is sort of prompted by the thought, well, when is the cause of action accrue, so to speak? In our submission, that isn't the right way of looking at Section 184I, because Section 184I isn't one of those, it's not like a sort of breach of contract where you can say on this date there was non-performance of a specific obligation and therefore the cause of action accrued at that moment. Section 184I is discretionary relief granted in response to a factual situation and the specific point at which one is entitled to come to court, so to speak, may result from an accumulation of factors, and when one chooses to press the litigation button will be a matter of taste. It can't be said that there is a cause of action that accrues at a defined moment. So what I just wanted then to do is just to, again, give a sort of mini roadmap of where I'm going within this main heading. Equitable considerations apply. Three things we need just to run through. The first is, on the indisputable evidence, was STIC a company in respect of which equitable considerations should have been taken into account? If so, secondly, on the indisputable evidence, has what has happened resulted in unfair prejudice? If so, thirdly, what is the appropriate relief? Now, as we submit, none of those is a question of primary fact. None of them really even involves drawing inferences of fact. They're all matters of evaluation, legal evaluation, of the legal significance of the undeniable facts. So turning to the first of those, was STIC a company in respect of which equitable considerations should have been taken into account? Now, as you will appreciate from our written case, one of our first main objections to the Court of Appeal's judgment in relation to this is that it did not even consider the application of equitable considerations when addressing itself to the relief sought under Section 184I at all. It did what the judge below did, which was to look in isolation at the specific allegation whether there was a whether there was a shareholders agreement at the very outset, whether or not the convertible preference shares would only be converted pursuant to unanimous agreement between the family members, and then looked again in isolation at the factual question, was there a family agreement in the hospital in Woollera in Australia that the convertible preference shares would not be converted without unanimous agreement, pending the discussions about separating out the family's interests by agreement. And it looked in isolation at Section 175 and the breach of Section 59 of the Malaysian Companies Act. What neither the judge at first instance nor the Court of Appeal did when considering the exercise of the jurisdiction under Section 184I was to address itself to the question whether STIC was a company in respect of which equitable considerations should come into play. Now, the Court of Appeal did turn to that issue in the context of its obiter consideration of whether or not, if we had had a freestanding winding up application, your Lordship and my ladies may recall that there was an application at the very end of the trial where we were saying, well, no, we're not just seeking Section 184I relief, we are seeking a winding up order, just an equitable winding up order in its own right under the Insolvency Act. And the trial judge said, no, you're not. Essentially, he refused what was an amendment application, and everything has to be looked at through the optics of Section 184I. So what our first point, as I say, is that the courts below both failed to address this critical question in the relevant context. Now, as I say, in one sense, that might be thought to be a purely structural complaint because the Court of Appeal does address the question of whether or not equitable considerations should come into play, but it does so only obiter, as I say, in the context of its consideration in case it was wrong on the question of the availability of an independent, just and equitable winding up relief. But if one then just...
that they found that there was no shareholders agreement and no family agreement,
yeah.
Why was their rejection of equitable considerations obiter? Because that was a third limb of your case, which they then did need to deal with. I can see if they'd found that there was a shareholders agreement or family agreement, then they wouldn't have had to go to equitable considerations.
If one just turns the pages of the Court of Appeal judgment, they do not address equitable considerations in the context of Section 184I. That is just a fact of how they approach the issue. They only turn to it obiter at the end when they're addressing the hypothetical question of just and equitable winding up. Now, as I say, in one sense, that looks like a structural complaint because they do look at it. But can we just look at what they then said at paragraph 170 and 171, which is electronic page 172,
Sorry, bundle page 172.
Yes,
Are they in
electronic,
line?
not the supplemental bundle, the main bundle.
Yeah, sure.
So what paragraph number again?
170 and 171. And you'll see that what the court says is Mr. Crow relied on Chow Kwok Chuen and the decision of the Singapore court in Lin Chu Mi to submit that STIC was a family company, and as such, when the trust and confidence breakdown following KN's death, the company should be wound up. We're not satisfied that these cases establish a rule that where there is a so-called family company, it must be wound up once there is a breakdown in trust and confidence. With respect, that wasn't our argument anyway. We were not suggesting there's any sort of rule. We were suggesting that the court needs to address the evidence and decide whether or not, on the indisputable facts, equitable considerations come into play because it was a family company in relation to which mutual trust and confidence was its foundation. We were not suggesting there was some rule of law in play. So with respect, the Court of Appeal simply, maybe my fault, misunderstood our submission. And then it goes on to say that it's a matter of fact in each case, which is true, but they then don't address the facts. And worse, they then say at 171, having regard to the judge's decision on the application for the late amendment of the claim, so that is the judge's decision not to let us run just an equitable winding up as a freestanding head of relief. So the Court of Appeal is saying the judge, having rejected our application to run just an equitable winding up in its own right, and because there are factual differences between sharp factual distinctions between the present appeal and Chow Kwok Chuen, the judge did not err in not mentioning the latter in his judgment. So with the greatest respect, what the Court of Appeal is saying is that the trial judge was entirely entitled not even to deal with the legal arguments that we advanced under Section 184I for two reasons. One is because we were not allowed to run a freestanding, just an equitable winding up, and the other is because there were factual differences between the Singapore case and ours. Now, in our submission, that approach by the Court of Appeal displays a fundamental misunderstanding of how this area of the law works, because it cuts completely against the approach that we've suggested you derive from Westmore Galleries, O'Neill and Phillips, which to an extent they recognise in the preceding paragraph that the question whether or not equitable considerations are in play is a factual question. It's not a question of fitting the facts of one case into a sort of an analogy, a close analogy with the facts of some previous case. It is a matter of factual evaluation on the material in hand. And if the court doesn't do that, it simply hasn't discharged its function, either at trial or on appeal. So that is our first...
equitable considerations don't sort of float around in the abstract,
no,
do they? One
exactly.
has to ask, well, what equitable considerations?
Exactly. And by reference to what evidence?
And I ask that because the courts below look quite closely at the two particular considerations being advanced, as I understand it, which is the shareholders' agreement and the family agreement.
Well, those...
They were said to be, weren't they, matters agreed outside the constitution of the company, to which equity should have regard. What other equitable considerations were being pleaded if those were not established?
In terms of the pleading, the re-amended statement of claim at paragraph 37, so bundle page 214. Paragraphs 37, 38, 39, 40, 41. I just got perhaps for, sorry, it's at electronic page 214.
37, all under the heading quasi-partnership.
Yeah. This is This is an entirely distinct pleading. Apart from the shareholder agreement and the family agreement, it is being alleged, as it says in 39, it was all material times the understanding among the brothers that the company would operate in the following way. Each of them would participate in the management and assume responsibility for the conduct. Each of them would be consulted on all major considerations. The company would not undertake substantial commercial activities without the prior consent of all the brothers. CPS would not be converted into ordinary shares in WTK Realty. Brothers would not direct or procure any shares to be transferred to third parties. And the arrangement would continue for the benefit of the beneficiaries of the brothers' respective estates on death. The brothers were quasi-partners, and the quasi-partnership operated harmoniously until the deceased met death. On the death of the deceased in March 2013, the claimant, as executrix of the estate and, or in her personal capacity, KY and KC became quasi-partners of the company. As a result, the claimant had a legitimate expectation that, among other things, she would be entitled to participate in the management of the company and be consulted on all major business decisions. So, essentially, the pleaded case, which simply isn't addressed in the judgments below, is not that equitable considerations come into play only because there was, in 2004, a shareholders' agreement not to convert other than unanimously, and not only because there was a family agreement in the hospital in late 2012, but because this was a quasi-partnership family company. And the evidential material that goes to support that, I just want to run through it, because it's not a question, as I say, of appealing against findings of fact. It's appealing on the basis that the indisputable facts haven't been addressed in considering whether that part of our case is made out.
What evidence was there of E, that the brothers would not direct or procure any of the shares to be transferred to third parties?
In relation to the shares in STIC, there was no direct evidence of that, but the inference that we invited the courts below to draw is this, that if you look at the articles of WTK Realty, there are two restrictions on share transfer. One is a restriction, I think, in Article 4 that says shares cannot be transferred or allotted in such a way as to transfer a controlling interest. And the second is in Article 27(1), which empowers the director simply to refuse to register any transfer without giving any reason. Now, STIC has no function. It is common ground. STIC has no function other than to be a vehicle for holding shares in WTK Realty. STIC is not a trading company. It's got no business at all. It is simply an ownership vehicle, an intermediate ownership vehicle between family members and WTK Realty. So the part of the factual context, and all of that is common ground, all of that is part of the factual context against which we were asking the court to evaluate whether or not equitable considerations come into play, was the restrictions on transfers of WTK Realty shares and the fact that STIC itself is purely and nothing but an ownership vehicle of WTK Realty shares. So, as I say, that's our starting complaint, that the evidential material is simply not addressed. The judge at first instance does repeatedly say that the WTK Group is a family business. He refers to WTK Realty as a family holding company. He refers to it as a family business, paragraphs 6 and 10. And then right at the end of his judgment, he just throws in paragraph 1715, where he expresses a conclusion that STIC is not operated as a quasi-partnership company, but he has addressed none of the evidence on which we relied in support of the conclusion that it was.
But what it's really F, 39F, and then how you expand upon that at paragraph 41. that the arrangement continues for the benefit of the beneficiaries of the brothers' respective estates.
Yeah.
What you mean by that is then that your client just steps into the shoes of her husband, and you say that regardless of the identity or skills or competence of the beneficiary or the executor of any of the brothers' estates, they're then entitled to participate in the management of the company?
Yes. And part of the...
refer us to a case where that's established?
A case? What, a reported decision?
Yes, where it's not only the brothers who have that entitlement, but their beneficiaries and their death.
We were inviting the court to draw the conclusion that that was what this group of companies involved, and part of the evidence was that we were already into the third generation. It is a fact that Dynasty was founded and the business was founded by WTK. He has 3 sons who are brought in as shareholders and directors. Within his life, their children, it's one reason I took you to the family tree, is that if you go through just the audited accounts of WTK Realty, you will see that the children, Patrick, Neil, Mimi, Pierre, Happy, are being brought in as directors, as shareholders. And so what we put to KC in cross-examination is that this is not a single generation business. This is, as I put to him and he accepted, this is a precious inheritance which was intended to be inheritable. And he accepted that in cross-examination.
Sometimes patriarchs like to exclude people who would not necessarily advance the interests of the company. And so, as a general proposition, they would like to include, but there would be an exclusionary.
Absolutely. And in fact, I can't remember which of the cases it actually is. One of the cases that in the authorities band is one in which there was exactly that. There was an overt exclusion of certain members of the family becoming directors. There was no such...
Were any of the daughters
no.
of the patriarch treated as allowed to be directors or managers?
Mimi is certainly a director of some companies, and I think Happy is company secretary of some others.
The generation below, though, isn't it?
Yes.
The
The
sisters of the brothers.
No.
None of those were involved in the company.
No. The structure that is, I'm reminded, it's the case I mentioned in answer to my Lord's question about it expressly excluding. There's a case, it's actually in the index under the name of Blossom and Doreen. I think it should in fact be under the name Tan and Tan. Blossom and Doreen are the first names of the...
I was more going on the proposition that it was implicit in patriarchs' activities, that sometimes they leave decisions as to who to be included and excluded to future generations.
Yes.
You don't need something expressly stated.
No, indeed.
They're more interested in perhaps the survival of the company than in the referring the interests of one particular descendant.
The case that we put, and I'll get to it later, but it is important to look through the cross-examination of KC. The case we put to him, and the main passages are in the electronic bundle. I don't ask you to go to it now, but it's the main passages start at about page 7697 of the cross-examination of KC. And the case that we were putting, and they carry on to 7703. As I say, the case we put is that this was a heritable business for the benefit of the successors of the successive participants.
That's quite distinct from it being a corporate quasi-partnership, isn't it?
Well, Your Lordship is, with respect, doing what the courts have since Westbourne Galleries exhorted you not to do, which is to think in terms of...
No, I'm just looking at your pleading. Your whole pleading was that it was a corporate quasi-partnership.
It uses that as a shorthand label. I entirely agree. But what that is trying to embrace is what I've said longhand is a company in respect of which equitable considerations come into play. By using the shorthand quasi-partnership, I'm not trying to fit within the sort of the three indicia identified by Lord Wilberforce in Westbourne Galleries of a partnership that is then incorporated with restrictions on share transfers and government
with respect, Mr. Crowe, the whole thrust of paragraph 39 of the pleading on page 214, these are corporate quasi-partnership allegations about everybody participating in the management, everybody being consulted on major decisions, everybody being consulted about a change in commercial activities. Then there's the little one about not converting the shares. Then that if you like, there will be a succession on death to include as corporate quasi-partners with all those rights to manage and consult on the death of their parents.
Yes.
That's not quite the same as saying this is an inheritable family business for everybody's benefit. I mean, it could easily be an inheritable family business for everybody's benefit in terms of ownership and benefit without being a corporate quasi-partnership in which the key to it is everybody having a participation in the management. I'm just looking at your pleading. Your pleading seems to focus not so much on it being an inheritable family business for everyone's benefit, but on it being indeed a form of quasi-corporate partnership with the added wrinkle, if you like, that when a partner dies, his successors become partners in his place.
Yes.
And not simply to be paid money from the business, but actually to step in the shoes of the brother.
Yes.
Yeah. Well,
but what I'm saying is, well, asking was, is there a case that's established that that's how quasi-partnerships work?
Well,
and
no.
So what was the evidence that you relied on to support 39F as expanded in 41? That was the expectation.
Your question, is there a case that establishes that's how quasi-partnerships work? With respect, that is a false question, because quasi-partnerships are not some sort of predetermined category which you have to conform to in order to engage equitable considerations. The question for the court is always and only, on the facts as they are, at large, is this a company in respect of which equitable considerations should be taken into account?
I can understand that as a general proposition of law, but where does that come up? Where do we get that from your pleading? Where do we see that you claim, regardless whether it was a corporate quasi-partnership with all the incidents set out in paragraph 39, it was in any event a family company in which everyone was expected to benefit, in relation to which general equitable considerations therefore arise, and incidentally, what are the relevant equitable considerations?
But with respect, that one can't take individual paragraphs without reading the document as a whole. And paragraph 42 makes clear that it is
between the quasi-partners. The
breakdown of the relationship between the quasi-partners, making it impossible, among other things, for the claimant to obtain information. And the complaint of paragraph
44 is squarely quasi-partnership.
Yeah. These are all individual in our submission. Elements of the breakdown of a relationship of mutual trust and confidence, which is what the sort of the umbrella term quasi-partnership captures.
But you say you don't have to show that there was ever a relationship of mutual trust and confidence between your client and the brothers. What you say is that there was such a relationship between the brothers, and when a brother dies, the executor or beneficiary somehow automatically steps into that relationship.
That is what we say. If you want to tie it to case law, the Singapore case that we rely on principally, exactly says, and that's what paragraph 31, we've quoted it in our case, the case of Chow Kwok Chuen, the difference between a quasi-partnership in the most conventional sense, which is the establishment, the voluntary establishment of a relationship between businessmen, well, women, and a family company, is that the relationship in a family company is given to you. You inherit a part of a heritable business because you are a successor to the previous participants. You don't choose, and you don't have to establish. The critical point is that in order for the equitable considerations to come into play in relation to a family company, a claimant doesn't have to prove that they established a relationship of trust and confidence, because it is the fact of inheritance that establishes the relationship. It is wished upon you. That is what a family business is. The relationship is not one of choice to go into a partnership. The relationship and the dependence of the family group on mutual trust and confidence is a fact of inheritance. And
even
so
if they never got on before the brother died, I'm not saying in this particular circumstance, just speaking hypothetically.
Factually, if they never got on, and the brother then dies, and because of a pre-existing tension between the family, that will be a good reason for the court to grant relief. It doesn't disentitle you to relief.
A relief to wind up the company?
Depending on the circumstances, yes. And we say specifically in relation to this company, winding up, I don't want to get too far ahead of myself, but winding up is specifically the right outcome in this case. Because normally the court fights against winding up and so regards it as the remedy of last resort because it is said to be an extreme remedy. And it's an extreme remedy because winding up a trading company may involve employees losing their jobs, suppliers losing supply chains, customers losing things they've ordered. None of that applies in this case because STIC is not a trading company. It's not, winding it up isn't an extreme remedy at all. It's not extreme in relation to STIC because it is simply a mechanism for holding shares in WTK Realty. It's not an extreme remedy in relation to KY and KC. And they have never pointed out, they've never pointed to any financial disadvantage to them that would flow from winding up. The reason they are keen on the buyout order is because it gives them exactly what they want, which is de facto control over this 14.4% shareholding, voting power in WTK Realty.
What would a liquidator do if the company was wound up? He'd either have to sell the 14% to the highest bidder, which might be somebody entirely outside the family, wholly contrary to what you say is the basis of this association, or he would sell it to the highest bidder within the family, in which case somebody who might or might not be your client, depending who had the deepest pockets, would end up in control of the empire. And that would be contrary to what you say the deal was as well.
A couple of answers to that, my lord. The first is you don't know what the liquidator of STIC will do. He could.
No, but you've got to ask if you're considering whether winding up is a sensible remedy.
What he could do is simply to distribute the shares that STIC holds to the beneficial owners.
Well, that would still, wouldn't it, transfer control to the other side of the family into the split which has emerged, because 2/3 of the shares would then go to persons other than your client.
And 1/3 would go to my client.
Yeah.
And what effect that would have on the voting control in WTK Realty would depend upon what the outcome of the appeals in relation to OS 39 and the 14.4 writ are. So, with respect, there are so many unknown elements. Your Lordship, my ladies, cannot take a decision about whether or not winding up is or isn't the right thing, depending on the hypothetical outcome of the other disputes going on in Malaysia with regards to the 4 million, the 1.252 million share blocks. Your lordships and my ladies simply have to take a decision today on the basis of the facts as they currently are. The facts as they currently are include the fact that WTK Realty has had a winding up order made against it. STIC has nothing other than shares in WTK Realty. WTK Realty, as of today, the day we're having this argument, is a company against which a winding up order has been made. What is the point, therefore, of keeping in existence an ownership vehicle, STIC, whose only asset is shares in a company which is subject to winding up in its country of incorporation? So we do say that winding up, you should, with respect, get your heads out of the sort of the default position they would be in relation to a trading company. You're not putting employees out of business, you're not putting tradesmen at risk. You're only dealing with an ownership vehicle in relation to a company which is itself in liquidation. Although, sorry, the order has been made, it's been suspended. That's the position you're in today. So, with respect, to suggest that winding up of STIC is the right solution is not an extreme remedy. All it does is to deprive KY and KC of de facto control over the whole of this block. And that, as we do suggest, is why they have not sought to appeal against an order being made against them in relation to a claim that was dismissed. Now, in answering your points, I got a little bit off track. What I wanted to do quickly was to get back onto track, addressing the material that was in front of the court and not in dispute, but simply wasn't taken into account in evaluating whether or not equitable considerations should come into play in relation to STIC. And I think we looked briefly at paragraphs 170 and 171 of the Court of Appeal judgment. Could we just look back briefly at paragraph 169, which is electronic page 171? And this is the extent of the evaluation of the material. Counsel for the respondent pointed out, rightly in our view, that there was no evidence in the present case of the circumstances in which STIC was incorporated in 1996. That is true, but we know it was incorporated. We know who the only three shareholders beneficially were. We were told by counsel that it was acquired off the shelf. That doesn't point one way or another. And that it was not used for any purpose other than to hold the CPS. Exactly. It was an ownership mechanism in the family group. There is no evidence to dispute this, and we accept counsel's assistance on this point. So what the court is doing is simply failing to recognise the legal significance of an undisputed fact. It's treating this, for some reason, as evidence that there isn't equitable considerations in play, when what they should have been doing is saying, oh, well, look, STIC is simply an ownership vehicle in relation to the family holding company. So it's got to be treated as part of the family holding company. There's no distinction in terms of legal appreciation of its status.
But the director and the alternate director were not members of the family.
No, but they took absolutely no decisions on their own at all. They did what they were told.
Why were they there? Why weren't the
I don't know.
family...
I don't know, but all I do know is that it is part of the agreed statement of facts and issues that F.K. Lowe, the de jure director, took no decisions of his own and did what he was told by KY and KC in relation to the conversion. He didn't exercise any judgment himself. The answer to your question may be, I can't give evidence, the answer to your question may be that STIC was set up as a tax-efficient means, potentially, for offshoring the profits of WTK Realty. If the shareholders in the Malaysian company are all Malaysian individuals, but you park a BVI company as a preference shareholder with no fixed coupon, that is a perfectly possible explanation for its creation. That it therefore has the potential for taking, in priority to all the ordinary shareholders, the retained earnings in WTK Realty.
As opposed to seizing control of Realty.
Yes. So the prejudice that is suffered, among other things, from the conversion is that it deprives the beneficial owners of STIC of that opportunity.
Why was the... I mean, one can't escape the fact that the conversion right was built into the shares.
Oh, yes, absolutely. But the fact that something is... I mean, the fact that somebody has a contractual or legal right to do something doesn't stop it being prejudicial.
Well,
that's...
But I'm one stage back in the analysis. If you're looking at these, at what STIC is there for, you can't ignore the fact that built into the structure under which it was set up was its right to convert the shares.
Well, one can't ignore that, I agree, but the only question for the court's purposes is what, if any, significance is there attached to that? And as I say, the one thing one does know, and I think it's paragraph 14 of the first instance judgment, yes it is that my client's evidence, Miss Ma's evidence, was that her husband, KN, told her that STIC had been incorporated to improve the tax efficiency of the family's holding in WTK Realty.
So what was the reference to that?
Paragraph 14 of the first instance judgment.
And why do you need it to be convertible in order to improve the tax efficiency?
I'm not an accountant. I can't give evidence. All I can say is that preference shares very often are convertible. We do know that the structure certainly appears to have been set up by Ernst & Young. EY were the auditors of WTK Realty, and their name is on the title page of the articles of STIC, and I think on the subscription agreement. And an EY trust company was the original subscriber to the shares of STIC when it was set up. So
if there's a holding by a court that actually it was a quasi-partnership and it was always expected that the children or the patriarch would manage the company and be the de facto directors, how does that affect the tax efficiency of the legal arrangements?
That doesn't affect, sorry, I think it doesn't affect the tax efficiency. We were simply exploring why, hypothetically, STIC was set up at all, rather than KN, KY, and KC holding shares, more ordinary shares, directly in WTK Realty. So the special, as I say, the special feature of the STIC shares is that, on the one hand, STIC does not represent a weapon of control within WTK Realty because it's got non-voting shares, but it does represent a tool of equal potential benefit to all the beneficial owners because it has this potential for the non-fixed preferential dividend. So that's the advantage of the preference shares. Sorry, my lady. What has happened as a result of the conversion is that what was a tool of equal benefit to all beneficial owners has now been turned into a weapon of control within WTK Realty.
It always had that ability to be a weapon of control.
Yes, it had that capacity.
And it was set up by WKN with that ability.
Yes, it was.
Potentially to be used by whosoever.
Potentially.
Well, if it was...
sorry.
If it was just carrying on from there, if it was a tax-efficient scheme, it may simply have been intended that control would be changed for the purpose of taking the company offshore.
Yes. Yes, indeed. And the courts below have pointed out that what has happened was contractually possible, STIC could convert. That is true, but in a sense that doesn't really answer the question with which we are engaged. By definition, on this part of the argument, we are debating whether or not the courts below should have come to the conclusion that the exercise of legal rights are subject to equitable constraints. So simply to say that the
constraint isn't a partnership constraint.
I'm sorry.
If the equitable considerations are not partnership considerations, because there is some separate concept that equitable considerations may arise from a family company which is there for the benefit of successive generations, regardless whether they're all to share in the management. What are those equitable constraints?
The equitable constraints are that at the highest level, in a circumstance in which the company has reached a state which nobody could have intended or expected when the association was formed, continuing to leave a minority shareholder locked into that company is prejudicial. Essentially, the classic breakdown of relationship. And as we say, the starting point of this appeal is that the judge reached that conclusion. Really, the debate we're having is what remedy should have been granted, and brackets, why on earth did he dismiss the claim?
If the only complaint is that a minority shareholder is being left locked in, then a minority shareholder who sought to get a winding up in face of an offer to buy his shares on fair terms would lose, wouldn't he? Because that would unlock his interest.
Well, as I think you yourself said in Lao Chu, the question whether or not a shareholder is acting unreasonably in pursuing a winding up remedy is one of the considerations. And if the, so to speak, the a priori preconditions for just and equitable winding up order are available, namely that there is a relationship of mutual trust and confidence which has so broken down that some form of break is required, then the onus is on the other side. I think this is paragraphs 20 and 21 of your judgment in Lao Chu. The onus is on the other side to establish that the petitioner, claimant, is acting unreasonably in seeking winding up. And on the facts of this case, we do say that the claimant is not acting unreasonably in seeking the winding up order. I mean, I rather got ahead of myself because I'm still on sort of item 1 of 3. The appropriate remedy wasn't meant to be coming for a little while yet. But as we say, essentially the arguments are that the buyout gives KY and KC what they wanted selfishly in control of the block of shares. Winding up is not an extreme remedy in this case. It would not cause financial prejudice to KY and KC. It is illogical to leave in place a company whose only function is to act as a part of an ownership structure in relation to a holding company in Malaysia against which a winding up order has been made. In those circumstances, in our submission, it cannot possibly be said that my client is acting unreasonably in seeking winding up. And as we will come to it when I get to that part of my submissions in more detail, there will, in our submission, be very serious problems if a buyout order is made. There will be very serious problems in reaching evaluation. Two things can be said about the buyout order. One is that it is committing the parties to further litigation in the BVI, because there will have to be part 2 of the hearing. There will be evaluation hearing. And it will be litigation which is entirely uneven, because all the information is in the hands of KY and KC, and it relates to a company, WTK Realty, which is not within the jurisdiction of the BVI court. So the valuation process is going to be long, slow, and bloodstained. And as it happens, the problems that my client will face in any valuation exercise are amply illustrated by another judgment from the BVI court in a case called Incredible Power. Let's find the page reference for Incredible Power. Which involved exactly the same parties, my client, KY, KC, and Janice Ting as a witness, in which a different judge found KC and Janice Ting guilty of repeated lies in evidence and fabricating at least one document. It's a case called Incredible Power, and it's page one. I don't ask you to go to it, but for your note, it's page 12395. And there are some swinging findings of on credibility, on deliberately withholding whole rafts of documentary evidence, dipping into it, as the judge says, at will on the part of KY and KC when they wanted to prove something, and, again, using the judge's expression, ex post facto fabrications. That is what my client will be condemned to dealing with if the buyout order is upheld. The advantage, by contrast, of a winding up order is that it is a clean break. An independent office holder is appointed, and it does not commit my client to further litigation in the BVI.
Well, there'll be potential for endless litigation by way of applications to the court in the liquidation for directions that the court should tell the liquidator what to do. There may be. All one can say is that, by definition, there will be further litigation if a buyout order is upheld. I wanted to move on because I've got slightly, as I say, slightly off course. What I was addressing you on was the evidential material in support of the proposition that equitable considerations come into play. One of the points I was going to be making, but it has come out in the course of our exchanges, is that the STIC it doesn't have any business of its own, and the court, as we just saw from paragraph 169, simply failed to recognise the significance of that undoubted evidential fact. What the court should have drawn from that is that STIC is part of the family structure of ownership. The next point, which the courts below simply did not appreciate the legal significance of which, is the complete absence of any documentary record of the basis upon which different family members participate in the companies. That level of informality in our submission should have been taken into account and recognised as being symptomatic of a group of businesses in which formality and legally binding contracts defining participation were unnecessary because the relationships were based on mutual trust and cooperation between the participants. I think I probably already made the point that by looking at STIC in isolation, rather than looking at it as part of the ownership structure of WTK Realty, what the courts below also failed to do was to take into account the significance of the fact that there are these two restrictions which I identified in answer to a question from my Lord Stevens, that there are the two restrictions on share transfers of a controlling interest at WTK Realty level, which is Article 4. I don't think I gave you the page references. So the page reference for Article 4 is 2679.
and Article 27.1, which is the director's ability to refuse to register a transfer without giving any reason, is page 2682. Again, because the court looked at STIC in isolation instead of considering it as part of the family structure, the courts below simply did not take into account the line of evidence that we put in front of it, and we put to KC in cross-examination, that what the company accounts show is that we are now onto the third generation of successors from WTK himself. The accounts show that directorships and shareholdings have spread out to the successors of the family members, and we submit that that is further evidential material, which is not in doubt because the accounts are there. They show who the directors are. They show Patrick and Mimi and Neil and so on becoming directors, becoming shareholders in WTK Realty. That is all further evidential material which ought to have been taken into account in deciding the extent to which this was a family business. The court also failed to take into account the evidence which I've already given you reference to, but just to sort of put it into the right sequence in our submission. The evidence of KC in cross-examination, particularly page 7699 onwards, where, as I say, he accepted. He said he never got on with my client, but he accepted that the basis of the operation of the companies was on a relationship of trust and confidence, at least between the brothers. Now, we submit that he was simply operating on the basis of a prepared script, because one of the many things we have listed in paragraph 40 of our case, the evidential material, which supports the proposition that family members participated because they were family. And you will see reference to a concern on the part of KY that my client's son Neil wanted to have Patrick removed, and KY says, I want to know why Patrick is being removed, because he's family. There are endless references in the evidential material on which we relied, which feature nowhere in the judgment, which indicate the extent to which participation in these companies depended on being a member of the family, not being good at your job, but depended on being members of the family, and the extent to which the participation succeeded down to the successors of the individual participants. In that context, you will have seen, I think, in the documents, a document for short we've been calling the yellow document. It's a copy of our closing submissions at trial, in which we highlighted for the Court of Appeal the submissions which we say were not addressed by the trial judge. My learned friend then put in comments explaining where he says the trial judge did deal with things, and we've responded to that. It's a laborious read. But if you look at least at paragraphs 41 to 43 of the yellow document, which is page 1029, you will see the wealth of evidence which we say simply isn't addressed. I don't ask you to go to it now, and it is, I'm sorry to say, slightly dry stuff to ask a tribunal of this level to go to. But it does, in our submission, illustrate the extent to which the evidential material is simply not addressed.
But was any of that evidential material evidence that, for example, when the patriarch died, his wife took over his involvement in the management of the company?
That specific piece of evidence, no, is not there. I entirely agree. What we do say, however, is that the courts below, in order to exercise the power that they have under Section 184I, have to evaluate the evidence that is put in front of them and to explain, if they are going to reject the case, to explain why they are rejecting it. And there isn't any proper evaluation of the material that was put in front of the court below. Quickly then, I've got to move on. The next
It seems that
point.
the patriarch wanted to exclude female members of the family.
Well, I'm not sure that's necessarily true, as I say, because if one goes to the... certainly it hasn't become true in the sense that female members of at least of the third generation are participating.
I'm just trying to think myself back into it. When this is set up, you say, by the patriarch, what was his attitude towards female members of the family?
There was absolutely no evidence about that, so I can't answer it, I'm afraid, my lord. But one of the things that ought to be borne in mind, of course, is that, as was said in Westbourne Galleries, companies are not inanimate legal fictions. They are the composite of the individuals who make them up. And as such, within a family group, things evolve. You can't just look at what the patriarch specifically intended, as if he wrote a charter that was carved in stone and couldn't thereafter never be changed. One's got to look at the evolution of the companies. And that is precisely the point of our point going to the evidence, in which the successors of the family become involved. The other thing, just moving on quickly, I've got to make a little more progress, I'm afraid. The other thing that the courts below failed to take into account is that as I say, because STIC is just an ownership mechanism, the thing that matters is WTK Realty, which is a Malaysian company. The Malaysian court has made a winding up order in relation to WTK Realty on the basis that it is a family company in respect of which the relations between the participants has irretrievably broken down, and therefore the just and equitable thing to do is to wind it up. Now, yes, there is an appeal against that, but your decision and the trial judge's decision and the Court of Appeal's decision all have to be taken against the background that that is the decision of the courts of the jurisdiction of incorporation of the holding company. Now, it doesn't prove that STIC is necessarily itself also a family company, but it is extremely powerful evidence that should have been taken into consideration, because STIC doesn't have a trading existence of its own. It only exists as part of the ownership mechanism in relation to a Malaysian company which has been held to be a family corporation, the just and equitable thing to do being to wind that entity up. And that, in our submission, is a very powerful consideration to be taken into account, and it features nowhere, and in fact quite the reverse. The courts below both said, I won't go to them, but paragraph 176 of the first instance judgment and paragraph 147 of the Court of Appeal judgment both say we're not going to take that into account. And in our submission, that is just wrong. It absolutely should be taken into account. And the fault lies, again, in legal analysis of indisputable fact and a failure to recognise the status of STIC simply as a piece of ownership mechanism. If you want it, the ruling in relation to WTK Realty is at page 6765. As it happens, there have in fact been 9. I slightly understated it by referring only to WTK Realty. The Malaysian court has made 9 winding up proceedings in relation to various group companies. Winding up orders in relation to WTK Group WTK Group companies. If you want to, the references there at 6744, 6754, and 6765. In relation to one of those winding up orders, a company called Arctic Star, KY was the petitioner, and he alleged that there had been a breakdown in relations such that it was appropriate for a winding up order to be made on the just and equitable ground. And when the Malaysian court gave its ruling in relation to WTK Realty, it said KY cannot both approbate and reprobate, as it said. In other words, he can't be alleging in relation to one group company that it's a family company in respect of which it's just and equitable to wind up, and in relation to others that it's not. Now, it may well be that the facts in relation to different companies are different. It is possible to have different outcomes in relation to different companies, but it is striking that 9 winding up orders have been made in the home jurisdiction, and it is wrong that none of those were taken into account by the courts in the BVI. So,
we don't know, do we, what the legal statutory provisions and/or associated jurisprudence in Malaysian law are about the circumstances in which you do or don't wind up a family company. I mean, it may be that it's word for word the same as an unfair prejudice regime, or it may be that it isn't, and even if it is the same, it may be that their jurisprudence does allow no-fault divorce, if one can put it in those terms.
My Lord, if any of these points had legs, they should have been argued and presented to the courts below and taken into account.
The reason I'm raising the question is that I'm not sure whether you're saying it's the fact that those companies are subject to appeal, a form of liquidation, that's relevant to the order to be made in relation to STIC, or whether the BVI courts should have, as it were, been swayed by the fact that these orders had been made by Malaysian courts into doing the same thing in relation to STIC, because STIC's just an ownership vehicle.
In relation to WTK Realty, the answer is both, because the fact that it's in liquidation is a relevant factor as to whether there's any point in leaving STIC still in existence. In relation to both WTK Realty and all the others, we do urge that the courts below should have taken into account the fact that we've had quite a lot of Malaysian company law. We didn't specifically have, I think, any evidence on the exercise of the court's just and equitable winding up jurisdiction, but I'm pretty sure we've got the provision in the bundles, and we can find it. The submission has never been made against us that this is all irrelevant because Malaysian just and equitable winding up relief is different. And that's not the basis upon which the courts below disregarded it. They said it was irrelevant, but they didn't explain why. And our submission is that it's not irrelevant, and if anybody's going to suggest that it should be, they need to make a reasoned case. And a reasoned case having been made, the courts below should have explained why they're discounting it, not simply disregarded it.
Do you have, or can you supply in due course, the electronic page numbers of which record the submissions that actually were made by your side to the trial judge and or the Court of Appeal about the relevance of the winding up of the other family companies? Don't do it now, but if you could supply it, I'd like to read them.
So, as I say, I need to move through my material a bit quicker. I obviously welcome the questions, but I need to develop the argument. So I've ticked off the first subheading of the first point, which is, should the courts below have reached the conclusion that equitable considerations were in play? If the answer to that is yes, the next question would be, on the undisputed facts, was there unfair prejudice in this case? Essentially, as I say, I mean, I probably made the main point in relation to this already, which is that the courts below failed to recognise the significance of the finding that the trial judge made in paragraph 178 of his judgment, where he said that it would be unfair to leave the parties locked in. He could only have reached the decision that it was unfair to leave parties locked into a company in which they couldn't get on if he had, in fact, accepted without recognising it that the basis of the relationship was one of mutual trust and confidence, such that when that relationship had deteriorated, relief needed to be granted. So our main point is simply, as I say, to suggest that the courts below failed to recognise and failed to follow through the logic of what the trial judge himself actually said, or actually found. The reasons why we say, apart from the breakdown in the relationship, why we say that there has been unfair prejudice in this case. Again, just to put in context a point I have already made, but in responding to a different question. The prejudice that is suffered qua shareholder of STIC is that before the conversion, STIC is a potential vehicle of profit extraction offshore from WTK Realty, whereas after the conversion, STIC then becomes a weapon of control in relation to WTK Realty. And the significance of those factors is simply not addressed in the judgments below. This is very closely related in our submission to the argument on the basis that STIC has lost its substratum.
Which they do address.
Sorry?
Which they do address.
They do. The main reason why the courts below rejected the loss of substratum argument, well, there were two. The trial judge says, I don't ask you to turn it up, paragraph 175. The trial judge says that STIC has not lost its substratum because the convertible preference shares were not mentioned in STIC's memorandum of association. That's his paragraph 175. In our submission, that is self-evidently a bad point. You do not identify, particularly in relation, as he accepted, to an off-the-shelf company. You do not identify the fundamental purpose of the company by looking at its purely formal memorandum of association. And if you even wanted an authority that vindicates that, we've included the case of Chua Kien Hao, which deals specifically with that point at paragraph 38, page 11246. It is common ground, as I say, Learned Friend recognises it in his case, paragraph 123, that the only function STIC has ever performed is to own shares in WTK Realty. If KY, KC and KN had wanted to be ordinary shareholders, or to add their ordinary shareholdings in WTK Realty, then ordinary shares could have been allotted to them. The specific value and difference of STIC is the fact that the shares were preference share, non-voting preference shares. The moment that situation has gone and it is simply a vehicle for holding more ordinary shares, it has, in our submission, lost its substratum. And to point simply to the memorandum of association to say, well, the CPS are not mentioned in the memo, really doesn't answer the point at all. The second point that's made in the courts below, or certainly in the Court of Appeal, is that the convertible preference shares were convertible, and therefore the conversion involved an exercise of a contractual right. That, in our submission, doesn't answer the point as to whether or not the conversion in this case involved unfair prejudice. Unfair prejudice, almost by definition, does involve the exercise of legal rights. It can involve unlawful conduct too, but we are, by definition, in this context, discussing whether or not equitable considerations come into play to make it inequitable to exercise a legal right. And you don't answer that point by saying, well, there was a legal right. Yes, there was a legal right. The question we're discussing is whether or not it was unfair to exercise it in the circumstances in which it was exercised in this case. There is, in our submission, again, useful consideration of the prejudice that is caused to a family member who is marginalised to the point of effective impotence. In the case of Lin Chu Mi, which is at page 12700, and we would particularly commend to you paragraphs 82 to 83, page 12720. So the third question under this first main topic of whether or not equitable considerations were in play, and if so, what, and if so, so what, is what is the appropriate remedy? If equitable considerations are in play, if there was unfair prejudice, what should the court have done about it? So far as that is concerned, in the course of answering a number of questions from the bench, I think I've probably covered a lot of the ground. Just to itemise the points, we have the fact of the winding up orders in Malaysia. We have the benefit of a clean break being provided by winding up. We have the countervailing curse of further litigation in BVI if the buyout order is upheld. We have the fact that winding up in relation to STIC is not an extreme remedy because it has no business. That is covered. There's, in fact, quite an interesting decision. Asia-Pacific joint mining is in the authorities bundle, and we would invite your attention both in relation to the relevance of litigation over valuation and the relevance of whether or not winding up would in fact involve putting anybody out of work or out of business. Both of those are issues that are covered in the Asia-Pacific mining case. Could we just commend to you paragraph 46 and paragraph 68 of that judgment at pages 10655 and 10660. I've already touched on, just finishing off with the why you should, with respect, prefer winding up to valuation. I've already touched on the problems that my client would face in any further litigation in the BVI dealing with valuation because both WTK Realty and the individuals KY and KC are in Malaysia, not in the jurisdiction of the BVI courts. The documents that would be required are entirely within their hands. And as I say, the decision in the case of incredible power does illustrate the cynicism of these individual respondents in dealing with disclosure and indeed with oral evidence. The incredible power judgment, I think I've already mentioned it, it starts at page 12395. I hesitate to give you a long reading list, but it is a very, very long judgment. So can I just give you some paragraph numbers which identify where the judge made swingeing findings against Janice Ting and KC of, as I say, deliberate lies, withholding documents, and ex post facto fabrications. At paragraphs 77, 86, 90, brackets 8, 107, 112, 116, 121, 174 to 176, 200 to 201, and 238. They are detailed and swingeing findings. And in our submission, they contrast starkly with the way the evidence was dealt with in this case. It is entirely possible that KC and Janice Ting told the truth at trial in this case and lied in incredible power. It is entirely possible the judge in incredible power just got it wrong. But our submission, when we come to the facts, will be that the judge in this case just did not recognise who was telling the truth and who wasn't at the trial. That will be my last point. But the judgment in incredible power makes for very striking reading.
Who was the judge?
Wallbank. Incidentally, just a small point. My learned friend's case suggests paragraph 180, brackets 5. He says that we did not raise any difficulties over valuation in the courts below. That is, with respect, not correct. We did. My learned friend has perhaps forgotten that we did address it in the Court of Appeal at page 8537, and he responded on it, albeit fairly lightly, at 8539.
Well, this judgment, though, that you've referred us to, was handed down in May of this year.
Yeah, that's right.
So substantially after.
Yes. Yes. I'm citing it to you as illustrative of the problems that my clients will face if the buyout order is upheld.
Oh, I see.
And since the relief that the court should order, as my Lord Briggs, I think, indicated again in Lao Chu, the relief that should be ordered in light of the material that is available in front of the court that's taking the decision. And this court is taking, this board is taking the decision as to what relief to be granted in light of that judgment. So I'm citing it to you for that purpose.
Well, the court has a certain jurisdiction to reopen judgments.
I'm sorry?
The court has a certain jurisdiction, very limited,
Yes.
to reopen if
Yes.
further facts come
Yes.
to light.
Sorry, can I just... The Malaysian one. Yeah. So in our written, in answer to your question as to where there is reference to our reliance on the relevance of the Malaysian winding up to the exercise of the court's jurisdiction here, it's in our written closings, trial, is that? Yeah. There are written closings at trial, paragraph 45.5, which is page 484. And then again in our Court of Appeal skeleton, paragraph 6A and 21B, which is pages 714 and 720. If you would also like our oral submissions, we'll try and track that down over lunch. Finally, just to finish off on appropriate relief, we do mention the possibility, if you come to the view that something went significantly wrong in the evaluation of the evidence, and evaluation of the legal significance of the evidence, but this board is not in a position on the material available to take its own view, as a poor fallback, there is the possibility of directing a retrial. My learned friend has suggested in his written case it is too late, he says, to ask for a retrial. This is at paragraph 181 of our case. I don't know whether from that he's suggesting we had never asked for it before, but the fact is that we did suggest it to the Court of Appeal as a non-preferred possibility at page 8557. My learned friend responded on it in his oral submissions to the Court of Appeal at 8858 and 8903. And we replied in closing in the Court of Appeal at 9112, 9124, and 9166. And that is why we apprehend the Court of Appeal mentioned it as a possibility in paragraph 55 of its judgment. So that is the first main heading. Failure to give proper legal evaluation to the factual evidence that was in front of the court. Second main heading I will deal with, I hope, more likely, because you already got quite a lot of the evidential material now in mind. The second main heading is that even if equitable considerations are not in play, the courts below should have reached the conclusion that there was nevertheless unfair prejudice, such as to justify relief being granted under Section 184I. And we say that on the basis of 3 points. One is loss of substratum, one is unlawful conduct, and one is justifiable loss of confidence in management. So far as loss of substratum is concerned, I've essentially already addressed you on that. The convertible preference shares had a unique status and a unique potential. They've gone, and once they've gone, they're irrecoverable. And the rationale in the judgments below for dismissing that as a loss of substratum simply doesn't hold up. So I move immediately to the second ground upon which, even absent equitable considerations, the courts below should, on the evidence, have found that there was unfair prejudice, and that is because there was unlawful conduct. And there was unlawful conduct in two respects. There was a breach of the BVI, Business Companies Act, Section 175, and there was a breach of the Malaysian Companies Act, Section 59. And I just want to deal with the BVI point, Section 175. You may just want, I don't know if you recall, but it's the provision that requires shareholder approval. Sorry, it's page 9493. If you want to have it open, it's the provision that requires shareholder approval in circumstances where a company enters into a sale, transfer, lease, exchange, or other disposition of more than 50% in value of its assets. And where that happens, shareholder approval is required. So there are a number of questions that arise under that heading. The first is, was the conversion?
Well, just pausing there. Bearing in mind that STIC is 2/3 owned by persons who appeared to have wanted the conversion to happen, is this a purely technical objection that it wasn't put through a shareholders meeting, or is it that it wouldn't have achieved the requisite majority?
It is, if you wish, a technical objection. There is a breach of a requirement of Malaysian company law, BVI company law. The thing, in a sense, the merits thread that runs through the complaints that we have is that what was done in disregard of a number of mechanisms which are put in place to protect minority shareholders' rights. And one of the points that Melania Friend seeks to make is that even if the matter had been put to a shareholder meeting of STIC, the resolution would have been passed.
It didn't require a special resolution, did it? I mean, not under Section 175.
No.
No.
No. So his point is that the resolution would have been passed, to which our answer is, well, unlawful conduct is unlawful conduct. And there is a recent BVI decision in a case called Somali and Ng, which is in the supplemental bundle at tab 6. I don't ask you to go to it now, in which exactly this point was run, by the majority, saying, well, I don't really know what the minority is complaining about, the outcome would have been the same. And it is interesting to look, again, it's a decision of Justice Wallbank, again, extremely long, but so can I just give you 3 paragraphs to look at, because in our submission it is a complete answer to my learned friend's attempts to avoid the significance of this. So the defendant's submissions in Somali and Lee, Somali, Lee and Ng, just to repeat, it's supplemental bundle at the report starts at page 102. The defendant's submissions are in paragraph 109 on this point, which is page 159. The claimant's response is at paragraph 113, which is page 164. And the critical decision of the court is paragraph 286, which is at page 238, which makes it clear that it is no answer to a complaint of a breach to say, oh, well, we were the majority, so we can disregard the statutory requirement. It is still a breach. If it's a breach of Section 175, Your Lordship called it a technical breach.
No, I was asking whether you called it a technical breach, and you said it was a technical breach.
Well, what I say is, sorry, by saying that, perhaps I conceded too much too soon. What we recognise, if by that question you're asking, could KY and KC have produced the necessary majority by voting, by instructing the trustee how to vote, then the answer is yes. They could have achieved, because it didn't require a special resolution, so they could have achieved the necessary majority.
And did the trustee have a sort of majority rule clause in it? I mean, how would the trustee have known what to do? Well,
there are actually, interestingly, that was one of the points. There are, in fact, 3 trust deeds. There's one trust deed for each of the 3 shares.
And they operate by majority?
No, each share...
Trust deeds or trustees?
Trust deeds.
Yes.
So there's one trustee, Gainesville is the trustee, and there are 3 trust deeds, one for each share, for each of the 3 brothers. Or, as it happens, since these proceedings began, the shares have in fact been transferred to my client, KY and KC. So
effectively, the trustee would have unanimity within each sub-trust.
Sorry?
The single trustee would, within each of his separate trusts, have a beneficiary and no doubt as to what he wanted the trustee to do. And since each trust owned a separate share, the trustee could perfectly well vote one share one way and the other 2 shares the other way.
If that's what it was told to do, I don't know how the trustee would have behaved. It might have found itself embarrassed to be...
But it's not a majority rule problem within a single trust.
It's not a majority rule problem within a single trust deed. No, I entirely agree. But so just running through the issues under Section 175, the first question is, was there a transfer, exchange, or other disposition? We say that converting the CPS does involve a disposition because the CPS are cancelled. This is not a situation where the rights attaching to shares are simply changed. This is a situation where at one moment, STIC owns convertible preference shares, and at the next stage, those shares have been cancelled and it owns entirely different and new shares. And the cancellation of the CPS is, in our submission, a disposition. The Court of Appeal's answer to that, paragraph 134, is that it wasn't a disposition because there was a contractual right to convert. Our submission, that is no answer at all. By definition, Section 175 is dealing with sales, leases, exchanges, or other dispositions which the company has a right to entertain. It has the power to exercise the sale. Simply to say it's got a legal right to do what it did, it doesn't answer the question as to whether what it did was a disposition. So the Court of Appeal's reasoning, in our submission, is simply wrong on that. One can then move simply on to the next issue, which is, if you still have 175 in front of you, assuming it is a disposition, was it a disposition in the usual or regular course of STIC's business? Now, so far as that is concerned, the Court of Appeal relied on what was said in a case called CBAN at first instance. Since then, that case has reached this board, and my Lord Burrows expressed the view in paragraph 53, page 11320, that the decision at first instance in CBAN was wrong. And in our submission, if you look both at the decision of my Lord Burrows in CBAN and at the decision of Justice Wallbank in Somali and Ng, as we've said, it is in our submission entirely clear that a one-off transaction such as this, which had the effect of disposing of the only asset that this company had, is not in the usual or regular course of its business. The CBAN decision proceeded on the basis that if you have a property holding company, it is in the nature of its business to buy and sell property, which may or may not be true, depending on the facts. But STIC was not a property holding business in the sense of an investment vehicle that had a portfolio of investments which it was buying and selling. It only ever had one asset, and that asset was cancelled. So given that this is a one-off transaction, never before happened, never subsequently capable of being repeated, in our submission the only conclusion has to be that it was not in the usual or regular course of STIC's business. My learned friend has also cited a great deal of Delaware law. I don't know if he's going to address you on it orally. I will answer if he does, but I will simply leave, so I don't leave it entirely unanswered, I will simply leave these thoughts with you. That if you look at the Delaware legislation, you will see that it is simply different. In the BVI legislation, Section 175 is engaged where there is a disposition of more than 50% in value. The Delaware legislation is engaged where there is a sale of all or substantially all of the business. And secondly, there is a significant difference between the BVI and the Delaware legislation because there is no equivalent in the Delaware legislation of the usual or regular course of business test. The courts have developed something cognate in Delaware, but it's not a statutory requirement. And I would simply, with respect, remind the board of what my Lady Arden said in the case of Masso and Shander last year about the dangers of trying to draw guidance from differently expressed legislation in different jurisdictions when you're interpreting the legislation of, in this case, BVI. And we would suggest again, if you look at what Justice Wallbank said in Somali and Ng at paragraph 286, page 238 of the supplemental bundle, it makes it entirely clear that the purpose of the BVI legislation is to protect shareholders, not to empower directors to undertake transactions without suitable scrutiny. The third question, quickly, just to wrap up on 175, if I could, before the break. My learned friend seems to seek to suggest that in paragraph 126 of his case, that informal majority approval is somehow sufficient. In our submission, you get no benefit at all from looking at the cases he cites, McDougall and Gardiner, Brown and La Trinidad, and Bentley, Stevens and Jones, he says the court doesn't grant relief where there has been an irregularity which the majority could cure in due course. Those cases, Bentley, Stevens and Jones and so on, are cases in which, first of all, the court is looking at the Foss and Harbottle principle, and secondly, it's looking at the question of whether or not to grant interlocutory relief to restrain the removal of a director by the majority when there may have been procedural irregularity in his removal, but the court knows perfectly well that the majority can remove him if it gets the EGM sorted out in proper form. All of that is very interesting when looking at interlocutory relief and the rule in Foss and Harbottle, but it's got nothing to do with whether or not there has been a breach in this case of Section 175. And in any event, on the facts, my learned friend cannot suggest that there was informal approval of any shareholder. His clients are not the shareholders in STIC. Gainesville is the shareholders. So he is having to construct an extremely artificial argument for saying that the informal approval of the beneficial owners of a majority of the shares is somehow sufficient to tick the box of a shareholder resolution under Section 175. And in our submission, there is simply no case law in that, and you should not drive a coach and horses through the statutory requirement. Same answer we would give to his suggestion that KY and KC could have convened an EGM at zero notice, which is another of the points. Again, they didn't. Speculating as to what might have happened doesn't answer the question as to whether what did happen involved a breach of Section 175. So none of that helps my learned friend.
We're not here concerned with the lawfulness, but with whether it's void or voidable. We're just concerned with whether it's a particular of unfairly prejudicial conduct.
Exactly so. And if I could just finish on that, I know I'm overrunning slightly into the lunch break, but on that, what my learned friend says is that it's not unfairly prejudicial because the conversion affected all the shareholders in STIC equally. And he says the conversion gave STIC more rights in WTK Realty. Now that, in our submission, doesn't answer the point. The point is whether or not there has been a breach of Section 175. It is the fact of that breach, unlawful conduct by the de facto directors of STIC, which constitutes the prejudicial conduct. It is unlawful conduct in the management of a company. And secondly, if the court, the board, were tempted to look at the commercial, financial consequences of the unlawfulness and look at whether the conversion is itself prejudicial, in our submission, the right answer, it was, because it deprived STIC of the potential of drawing out the preferential dividend, and it delivered instead voting control to KY and KC. So the conversion impacted differentially on KY and KC as against my client. So with those points, we would submit there has been a breach of 175. The next step would be my learned friend, Ms. Boardinghouse QC, addressing you on Section 59 of the Malaysian Companies Act, but I'm conscious that I've already overrun, so I don't know if that would be a convenient moment.
Nonetheless, we will resume at 2 o'clock.
Grateful.